This is an interview with Justice R. Eugene Pincham, Appellate Court of Illinois, 1st District, retired, and Judge Earl E. Strayhorn, retired judge of Circuit Court of Cook County, with regard to their experience with the practice of law in Cook County, Illinois. Why don't we start, Justice Pincham, with you talking a little bit about how you came to Chicago and your training and how you began practicing law.
I was reared in Limestone County, Alabama, which is in North Alabama, on the north side of the Tennessee River. On the immediate south side of the Tennessee River was a town called Decatur. And in Decatur, the famous Scottsboro Case was tried, Powell versus Alabama. This is a case in which 9 black youths on a freight train out of Chattanooga, Tennessee, en route to Memphis during the Great Depression were taken off the freight train in Scottsboro, Alabama. And within 2 days, they were arrested, charged, tried, convicted, and sentenced to die for allegedly raping 2 white women who were found on the same freight train they were taken off. The case created great furor in America during the time. As I said, it was during the Depression. And the Supreme Court of the United States reversed the conviction at the instigation of the NAACP and several other civil rights groups, and held for the first time a landmark case that a defendant charged with the commission of a capital offense must have loyal counsel appointed by the state to represent him. The case was tried a second time, and on the second trial, the judge who presided over the case was a judge named Horton. Judge Horton lived in my community in Athens, Alabama, and one of his domestic servants was a lady named Sister Annie Friend, who sang in the choir in the church I attended, Fraser's Chapel, CME Church, in Athens, Alabama. The boys were tried again and were convicted, and again sentenced to die. Shortly after the conviction, second conviction, the doctor who examined the two young ladies, as well as the 9 defendants, came to Judge Horton and told him that 2 of the defendants who had been identified as participating in the rape could not possibly have participated in it because they had venereal diseases so badly that they could not possibly have been engaged in the sex act. Judge Horton asked the doctor if the state's prosecuting attorney knew that, and the doctor told him yes, and Judge Horton wouldn't know how, and the doctor told him, well, the doctor told the prosecutor. Judge Horton called the prosecutor in and told him that he was going to grant him a new trial because this information had been withheld from the defense attorneys, and the prosecutor told Judge Horton that if you do, we will ruin you socially, politically. And Judge Horton said, well, I don't have to worry about what you do to me. I have to worry about what I'm going to do when I get to the pearly gates, and I've got to look my God in the face. And he granted him a new trial. And in fact, Judge Horton was ruined and had to leave Limestone County and tore down his house, which was used as a hospital during the Civil War by Confederate soldiers, and rebuilt his house in East Tennessee. That case tremendously influenced me as a child.
How old were you at that point?
Oh, I guess about 10, 11 years of age.
And of course the trials go on and on and on.
Yes,
There's
yes.
so many, 9 trials, something
Yes,
like that. Unbelievable.
They ultimately were, some of them were killed during these trials, that is, accidents and what have you. 2 were finally released and spent the rest of their days in Detroit, if I recall correctly. I attended an American Missionary Association school, which was American Missionary Association was a abolitionist organization that founded the school I attended in Limestone County, Alabama in 1869. Our teachers were from New England, and they'd instilled within us the notion that we're supposed to use our lives to better the lives of others. So when I finished college, I came to Chicago.
Where did you go to college?
Tennessee State. I first went to Lemoyne College in Memphis, Tennessee, which also was the American Missionary Association school. I was expelled from Lemoyne College twice for deportment and academics. And it was the greatest lesson I learned. And I left Memphis and came to Tennessee State and got my degree, bachelor's degree at Tennessee State, and then came to Chicago on a freight train, incidentally, and enrolled in Northwestern.
Judge Pincham, you told me once why you left Alabama. Why was it? Something having to do with some advice you got from your mother, I thought.
Well, it was a foregone conclusion that we were not going to remain in Athens as we grew up. We were deeply indoctrinated with doing exceptionally well in academics. My mother didn't want me to leave, really, but I had to because, as I now look back over it, there was nothing there for me. I chose Northwestern University School of Law for several reasons, one of which was I had written a term paper in high school about the Northwest Passage. And in writing the term paper, I came across information about Evanston, Illinois, and the clergyman who founded the community and the clergyman who founded Northwestern University. And I was impressed with that. Secondly, I came to Northwestern because it enabled me to take a freight line directly from Athens to Chicago without going through a freight yard. And that was one of the motivations. Another one was it was closer. I was accepted at most of the major law schools, much to my surprise. But you look shocked.
No, so you had already applied and been accepted when you came to Chicago.
Yes.
So that had required quite a bit of planning on your part. You had applied to these law schools, gotten yourself accepted, and then you came all the way up here ready to go.
Yes. Well, it didn't require any planning any more so than getting here.
And going to college.
And going to college and doing well in college.
Yeah.
And I learned at Lemoyne that it was important to do well academically. Mm-hmm. And when I went to Tennessee State, I was mature and aware, and I did well academically. In other words, as the old saying goes, I got my lessons. Mm-hmm. So when I applied to various law schools, I was admitted. And I chose Northwestern, and I'm grateful that I did. And I enrolled in Northwestern in January of 1948. Most of my classmates were veterans. I was not a veteran. I was the only black in my class. There was only one woman in the entire law school, Elaine Straschild. Harold Washington was in the class behind me at Northwestern. I was expelled from Northwestern University every semester because of financial circumstances. The bursar, whose name is Evelyn Klepak, was very, very kind to me, and every semester when I got the expulsion notice, I insisted upon going to class. The professors would say to me after class, "We have an expulsion notice from you, Mr. Pincham." I said, "Yes, I know, but I'm going to come to class anyway." They said, "Well, you're not supposed to." And I said, "Well, they don't pay you to fight. They pay you to teach, and to expel me, you're going to have to fight me, and you can't whip me, so I'm coming anyway." And they allowed me to come. And
you weren't going to go quietly.
No, and he knew that. It arrived. We got to the point where Miss Klepak,
the bursar,
mm-hmm. would give me a pass, and she'd see me coming into the registrar's office. She started writing out the pass.
Good.
Because the first time I went there, she refused to do it, and I said, "Well, I'm going to sit here until you give it to me." And I sat there for about 4, I guess, or maybe 3 o'clock until about the office was closed, and when she got ready to close, I said, "I'm not going to leave. You give me a pass." So I got through, and I'm the first student, to my knowledge, to graduate from law school and walked and got a degree owing the money. The rule was you were not supposed to have the degree conferred if there was a balance of tuition. And again, Ms. Klepak was very kind to me, and gave me a pass to get
for graduation.
Yes, for graduation.
Excellent.
And to take the bar.
Excellent.
You couldn't take the bar owing money.
Good.
And she gave me a pass owing, when I was owing the law school money, to take the bar, and I was able to take the bar owing law school money. I paid them, of course, but I'm here because the shoulders I stand on, Evelyn Klepak, J.T. Wright, the principal of the high school that I attended in Athens, Alabama, Dr. Price, the president of Lemoyne, who was kind enough to expel me from Lemoyne, and
We
Dr.
won't go
Walter
into those
Davis, Dean
details
Gore,
if you
who
don't
was
want.
President and Dean at Tennessee State. There were no such thing as academic scholarships. If they were, they were not offered to us. You just bulldoze your way through.
Well, Gene, wasn't Cecil Partee also a classmate of
He
yours?
was ahead of me. He was about 3 years ahead of me.
Judge Strayhorn, perhaps you would like to give us a little summary of how you came to go to law school and what encouraged you to go to law school.
Well, I'm not originally born in Chicago. I was born in Mississippi. And my folks came here in 1927 or thereabouts, just about the time, Tom, that the criminal court at 26 in California was being built and opened. But of course, when I got here, I didn't know anything about that building, or I had no interest. I'm 7 years old, and I don't have any interest at that time in going to law school. But I went to elementary and high school here in Chicago. My undergrad work was done down at the University of Illinois, and like Gene, I had a life learning experience my first semester there at Illinois, when because of the fact that I was away from home for the first time in my life, not having my mother to tell me that I had to study, I proceeded to play through that first freshman semester, to the extent that my grades were of such a poor character that I received at the end of that first semester a notification from the dean of the school that I would not be permitted to re-enroll for the spring semester. Illinois was on a semester system at that time. It might be still as far as I know. And so they kicked me out like Lemoyne kicked Gene out. And I had to come home and face my mother and explain to her what had happened.
That was not a happy day.
It was not a happy day, but she received it much more civilly than I had expected her to receive this kind of a notification. And that really motivated me to put my roots down and mature and go back to school and study as I was capable of doing.
Talk a little bit about what it was like to be a high school student in Chicago at that time.
Well, I went to Tilden Technical High School. At that time, Tilden Tech was an all-boys school. There were very few blacks in the enrollment there, maybe out of the entire enrollment of 2,500 probably. There were probably no more than 25 or 30 blacks, so we all knew one another. We got along with our classmates.
Was it, when you say it was a technical school, was it a neighborhood school, or was it a school you had to have an entrance exam to get into, or what did that mean, a technical school?
No, I didn't have to have an entrance exam. I graduated from an elementary school, and when I applied to go to Tilden, my application was accepted, so we did have to apply to be accepted in the technical school, and it was technical because it had various shops. Machine shops, tin shop, print shop, things that were really designed for preparing the graduating students to go in the workforce in the particular shop that they had concerned themselves with during their period of time at Tilden. And I went to Tilden primarily because my friend was going to go to Tilden, and I didn't want to be separated from my friend Harold Murray was his name, God rest his soul. and we went to Tilden together from our location there at 50th and Prairie. We had to walk to school, even though at that time the streetcar would take boys our age for the paying of a fare of 3 cents. But our families were not able to afford us that kind of a luxury, so we walked to school. And we would walk every morning. I was living at that time at 52nd and Michigan Avenue in Chicago, and I would walk down 51st Street. There's a big, wide railroad viaduct there that extends from about Stewart Avenue to Wallace. And that was the neutral zone. That was the free zone. We would walk through that viaduct, and then when we got to out of the viaduct at Wallace and 51st Street, then we would have to fight our way from 51st to 48th Place and Union. But the fighting at that time was with rocks and our T-squares, and our shields were our drawing boards, because we had mechanical drawing, and so we had to use these boards to pin our plots on. And our boards were our shields, but as I stated, when you fought in those days, the fighting between gangs, and there were gangs existing then, were not of the lethal kind, but the kind that the boys took place in at that time with rocks and stones and other kinds of non-lethal weapons.
So when you say that was the neutral zone, you mean the neutral zone for gangs, or the neutral
It was a
zone for
free
blacks
zone,
and
the
whites?
neutral zone for from blacks and whites, and for gangs, and that was a free zone. You were safe in that particular. Both sides were safe. Whoever was using that particular viaduct didn't have to have any fear of having a rock thrown at him or being attacked by a member of the other neighborhood gang. And that went on for 4 years.
So let's go to the period when you're in law school, and what motivated you to go to law school.
Well, as I said, my motivation for going to law school was the things that I experienced in going to college. I had my major was political science. I minored in American history, and my major subject and my minor subject covered some elements of that concerned legal activities, and that interested me. And when it came time for me to begin to think about what it was I was going to do when I graduated from college, law cropped up in my mind. And I had, when I graduated, pretty well made up my mind that I was going to go to law school. But when I did graduate, I knew that I was going to have to put that wish on hold, because we were then, the world was then, at least Europe was then, in war. And it was expected that we were going to join that war at some point in time. I knew that I was going to have to be drafted, because the Selective Service Act was passed right before my graduation from college in October of 1940. And I knew that I was going to have to serve a year to do my service obligation. So I went to work after graduation, working as a clerk in a Kroger grocery store, pending my receipt of my selective service notice to report for military service, which I received on October 15th, the 1-year anniversary of the passage of that act. Directed me to report to the Selective Service Office down on Van Buren Street here in Chicago for my year's service. And
then you say you were shipped to Italy?
nope, I was shipped to Fort Custer, Michigan, and I did all of 2 weeks basic training, and then I was shipped to Tuskegee Air Force Base in Tuskegee, Alabama, and I was serving there on Pearl Harbor Day, when all bets were off and we were in a total war, and that year's period turned into a 6-year period. And it was during that 6 years that I was in service that I met Cyrus Coulter, who was an attorney, a practicing attorney here in Chicago. Cy Coulter was a wonderful person. And it was in our conversations when he and I were talking in the night there over in Italy, that his encouragement of me going to law school solidified in my mind the fact that if I lived and if I returned, that I was going to go to law school. And I did. God willing.
Justice Pincham, I wonder if you could say a few words about your introduction to practice. Can you tell us what your first legal job was and how you progressed on?
In 1948, when I enrolled in law school, in 1951 when I came out, that was half a century ago. And the circumstances then were appreciably different than the circumstances are now. By and large, and I did mention this to you earlier, there were but only one or perhaps 3 areas in which blacks could go upon graduating from college. Some could go into the divinity, go into ministry. I had always had an inner desire to be a minister, but I overcame it because I didn't feel that I was willing to live the kind of life that I thought a minister should live. I wanted to do those things that culturally I was told and taught ministers shouldn't do. So that eliminated me going into the ministry. Being a teacher in the rural areas of the South was another area that we could go into as blacks, and I certainly didn't want to do that. We could come north, migrate north, and try to get a job at the post office, or as a fireman, or in the police force, police department. I didn't want to do that either. And the only other areas left was coming to law school, or dental school, or medical school. And my college career, I had deliberately avoided the physical sciences. And I had thought that to become a doctor of dentist, you needed academic background in the physical sciences. I later learned that's not true. Matter of fact, I know people who became doctors who majored in Spanish in college. But that was the perception at the time. So the final opportunity was to go to law school, and I went. When we finished law school term, we were not offered jobs, by we I mean blacks, were not offered jobs as clerks for judges. They didn't even interview us at the law school for the big law firms and what have you. We were unaware that you could go into the government jobs were just not available to us. So when I came out of law school, January of 1951. I ran an ad in the Chicago Daily News, which was the afternoon newspaper in Chicago. I had spent $2 to run the ad. And the ad went something like this: R. Eugene Pincham with a phone number, Northwestern School of Law graduate, waiting to take the bar exam, need job. That's what the ad ran, $2. I got a call from a man named Earl Trulich. Trulich owned a fast food restaurant, a Jack and Jill fast food restaurant on East 55th Street, east of Cottage. And he asked me to come to see him, and I went. When I walked into the restaurant, he was sitting at the bar, and he started shaking his head in the negative. When he introduced himself to me and I introduced myself to him, he said, "I assumed that you were white, and I needed someone here to manage my business during the time I'm absent. But the community is not ready yet for a black to serve in the capacity of a manager. And I'm sorry, but I cannot hire you." I said, okay. I returned home. I was living at 65th Aberdeen at the time. When I returned home, my wife said to me, "Mr. Trulich just called. He wants you to come back." I said, "Well, I don't have the car fare to keep running back and forth." And I went downstairs and borrowed $1 from my dad, who lived in the first floor. Went back. When I went back, Mr. Trulich said to me, "My conscience will not allow me to do what I just did." He said, "I'm willing to give you a job, but at the same time, I must not lose my business. If you're willing to work in the kitchen and wash dishes, I'm a graduate of Northwestern University School of Law with a JD degree, don't have a job." He said, "If you're willing to wash dishes and let the community get to know you, I'll give you a job and we could work your way out." He paid me $50 a week. I worked 6 days a week, from 6 o'clock in the evening until 1 o'clock in the morning. And I was glad to get the job. And truly proved to be another shoulder on which I stood. I took the bar, I believe it was in March, April of 51, and passed. I still have the 50 questions they asked me right now. I must confess that I don't say this in a derogatory sense, I say it in a realistic sense, that I have very, very little appreciation for the bar exam, because of the 50 questions that were asked, I knew the answer to only 2. And in fact, the last day of the exam, I mistimed myself and left the exam 2 hours ahead of time, thinking that the time had expired.
No.
But I passed. I then began to look for a job. I went to various law offices. There's no point in even thinking about going to a white law office. It was just out of the question back in the 50s. Matter of fact, I didn't even know where the white law offices were. But I was told about a fellow by the name of Joseph E. Clayton, Jr., who was a very prominent lawyer. To make a long story short, I chased him for about 3 months, and finally he agreed to give me a job in his office. 9 until 5, $20 a week is what he paid me. And at 6 o'clock, I'd go back to my job, washing dishes.
Well, Clayton, at that time when Gene went into his office, was the preeminent criminal defense lawyer in the entire state of Illinois.
That is true. And Clayton had asked me, he said, first, I was going to take over his divorce practice, because he was a criminal lawyer and he had a tremendous amount of divorce work. In fact, Joe Lewis is one of his clients in the divorce case. And I'll try to make this quickly. I went to divorce court about 6 or 8 days. And I finally came back and told him, I cannot do this. I felt like a prostitute in divorce court. On the one hand, I'm arguing on behalf of a father not to pay support for the support of his children. Next case, I'm arguing on behalf of a mother against the father for support of a child, asking that the man making $100 a week give his wife $90 a week for support of her and a child. Next case called, I'm asking that the father, who's making $1,000 a week, only give the mother $50 a week for herself and 10 children, and I felt like a hypocrite. And when I went to him and told him I didn't like it,
Yeah.
he said, okay, and he called me chief, you go with me. And I started going to 26 in California with him.
Why
Every day.
Why did you feel more comfortable doing criminal work than divorce work?
Well, I was taking consistent positions every day rather than inconsistent positions, and it was very, very uncomfortable standing before the same judge, the same day, within a brief period of 2 or 3 hours, taking inconsistent positions, contradictory positions.
Now, you were primarily a defense criminal attorney,
That's
correct?
correct. That's correct. And after going with Clayton to 26 in California over a very brief period of time, he said to me, how much are you paying? How much is Mr. Trulick paying you at your job? I told him $50 a week, so he said, okay, I can pay you that. And he began, when he agreed to give me $70 a week, I quit my job at Trulick's and devoted full time to Clayton. And we'd go to court every day at 9 o'clock, get back in the office about 4:35, and from 5 o'clock until 11 or 12 o'clock, he had a tremendous practice. I did his brief writing. And the first case on appeal that I authored the brief was People of the State of Illinois versus Eugene Philip Childress, which was a capital case. Clayton had been assigned the case to appeal it, he didn't try the case, by Judge Leonard. And in those days, appealing a criminal case was very, very cumbersome. We didn't have the Civil Practice Act. You had the writ of vericorum nobis about appeal and all this, these procedures. And
Did you have the full transcript of the trial?
Oh yes, we got a full transcript of the trial. And incidentally, the case was not argued orally in the Supreme Court, and the Supreme Court reversed the conviction solely on the brief that I wrote. Another case that I took of Clayton was United States of America versus Savannah Hinton in the Seventh Circuit, where I wrote the brief in that case. And the court pointed out in the opinion that counsel for the appellant did not appear, so we took the case on the written briefs of the appellant and reversed the case. I did his brief writing. And I would say to any young lawyer, the best thing that can happen to you when you come out of law school is to go into brief writing. It gives you great appreciation for what you're doing and what have you.
When I came out of service, I had already been accepted at DePaul by mail. And so when I got home in early January of 1946, I knew that I was going to be going to law school, and as a matter of fact, the first 2 weeks I spent down at the law school, which at that time was located at 64 East Lake Street. I went to class in uniform because I didn't have any civilian clothes that fit me. And I was a member of DePaul's first post-war class. It was nothing but returning war veterans in that class. It was 77 members, I think, in that class. 75 men, 2 women. The women were the only members of the class that were not returning war veterans. So the maturity level of that class was extremely high. And we were all interested in catching up on the period of time that we had lost in service. And so we were interested in moving ahead and going on and graduating from law school. And we pushed the administration so hard that they let us do all of our law school work 3 years in a period of 2 years by going to school throughout the year, with the exception of 1 week off for Christmas, for 2 years. And that was the most exhilarating educational, intellectual experience that I've ever gone through. The intellectual level in that class was so high, and the intensity and interest was so great that every day you were looking, I was looking to go to class.
Did you have any experiences like Justice Pincham's experience with the bursar?
No, because I was a beneficiary of the GI Bill of Rights.
GI Bill, right.
And all of my law school expenses were paid by the government.
Huge
But
difference.
I was working also, and I was working in one of those jobs that Gene just spoke about. I was working as a clerk at the post office, and I would get through my class at 12 o'clock. I would study in the library from 12 until 4, and then I'd go to work at the post office at 4 o'clock. But I didn't make enough money at the post office because I was only part-time. And I had to find another job because I was married and had a child and a wife. And the stipend that I was getting from the government wasn't enough. So I had to get a job that gave me more money. And I ended up going back to the job that I had held when I was in college in the summertime, working as a red cap at the then Illinois Central Station at 12th and Michigan, where I made enough money hustling bags from those trains to sustain me and my family while I was in law school.
What was the situation you found when you graduated and you started to look for a job as a lawyer? How did you go about that?
When I graduated law school, we were in the midst of a political campaign. I graduated in June of 1948, and we were in the midst of a political campaign. And one of the candidates, local candidates, was running for state's attorney of Cook County, and his name was John S. Boyle. And John S. Boyle was a enormous figure, both physically and in every other respect. As a matter of fact, his campaign promise was a big sign spread over the billboards of this county with him in his full height, 266 foot 6 inches tall, with his finger pointed, and above his head the sign, "Gangsters fear this man."
And did they?
They did. He was elected. But I was on his veterans committee. One of my classmates, Dennis Horan, was the nephew of a big Democratic ward committeeman in the Democratic Party by the name of Horan. And Dennis was the chair of the Boyle Veterans Committee, and Dennis asked me early in the campaign if I would like to join in with him in helping John Boyle, and I did, and I was a gopher. I answered telephones, I ran, got coffee, I licked the envelopes, and I worked in his campaign. And when he won, then he asked me, he said, "Well, Earl," he says, "I want to thank you for your help in my campaign. What can I do to help you?" I said, "Well, John, I want to go over the West Side with you." Well, at that time, there were no blacks, no Negroes, as we were called then, in the state's attorney's trial division. There were Negroes in the office, and they had very substantial jobs. As a matter of fact, the head of the appeals division was a black. His name was Morris. I think his first name was Ed. And there was also another black man in the appeals division by the name of McCoy. But there were no blacks, and there had never been any blacks in the criminal trial division of Cook County at that time.
So did you go into that division?
I did not go into that division at that particular time. I went to work for John Boyle after his election, and 2 years after I was in the office, then I ended up in the criminal trial slot as the second black to be assigned to the criminal trial division at 26 in California. The first preceded me by a week. His name was Archie Lassen. He became a judge. Unfortunately, he's passed on. But Archie preceded me by 2 weeks. And then when I went in, I was assigned to the courtroom of the former state's attorney of Cook County, Judge William Toohey, who was my first judge, and my first partner was Bob McDonald, our mentor. The assistant state's attorney that taught Bob and me was a man that ended up as a judge of the Court of Claims in Illinois. His name was Leo Pock, the smartest lawyer I've ever met. And he taught us. And it was while I was in the state's attorney's office that I met Gene, because he was coming in handling the calls for Joe Clayton.
So you were on opposite sides of the fence at that point. You were a prosecutor and he was a defense attorney.
Absolutely.
So how would it go in court in those days?
Well, in those days, there was a great deal of civility. The fact that you were on opposite sides of the fence in terms of trying a case did not carry over to personal relationships. You fight like cats and dogs in the courtroom, but after the court recessed, then you go to a bar and you'd have a drink with the person you'd been fighting with all day. We became friends, and he was doing his work for Joe Clayton, and I was doing my work for the people of the state of Illinois. And there the twain met.
Can I ask you both, who the law teachers you remember are from your law school experiences? First you, Judge Strayhorn.
Well, I remember my real property teacher, Max Rapaz. I remember my contracts teacher, and now I'm getting a senior moment because his name is gone. I remember my torts teacher, and I remember our Dean Taft.
I very vividly recall my law school professors' names. Francis Allen was one of them. Pedrick was one of them. Cedar was one of them. Dean Rawle was one of them. Rawle ultimately became the dean of the law school. As a matter of fact, Rawle interviewed me for my admission to the law school. When I was admitted to law school, Dean Rawle interviewed me and told me I was admitted. During my days in law school, I worked as a waiter in the Empire Room in the Palmer House. I went to the law school in the daytime. In fact, Northwestern did not have a night class school. My first class was 8:30 every morning. My last class was over at 5. I walked on the floor of the dining room in the Empire Room in the Palmer House at 5:30. The maitre d', my boss, was a man named Jaffe. And Jaffe admonished me, do not let these people know you're in school, because if you do, I'll have to fire you. And of course, I didn't let them know. Jaffe allowed me to leave the dining room when the dinner hour was over at about 9:30, 10 o'clock. I would go down in the basement of the Palmer House and hide under laundry hampers, and make me a place where I studied. I would come up about 1 o'clock when the dining room was closed and catch the train to go back south to Inglewood And the motorman, the conductor on the train, many days, I could hear him hollering, come on, schoolboy, and I'd run to catch the train. And I'd fall asleep, and he'd wake me up at Racine Avenue where I was to get off the train. On Saturdays, I shined shoes at the shoe parlor still there. It's on Van Buren between State and Dearborn Street, where I shined shoes on Saturday. I must say this to you also. I too was married. And I'd be remiss if I did not say to you that my wife is responsible by and large for me having gotten out of law school, from having succeeded in the practice, and she stood by me. We've been married now 56 years, come the 31st of August of this year.
I got you beat.
Yes, you have.
Well, congratulations to both of you.
She was loyal. Her name was Alexander. We married. She was my college sweetheart. And she worked for the first 10 years of my practice, teaching school, birthed 3 children, and after 10 years of marriage, we decided she could stay at home and raise the children. I continued to practice. As fate would have it, Clayton passed away in 1955. I'd been with him then 4 years. And I was known as one of Clayton's associates. And he passed suddenly. He suffered from asthma. He's only about 55 years of age when he passed away. Had a huge practice, a tremendous practice. I would hazard to say Clayton had 15 or 20 murder cases on the docket at any one time. And when he passed away, he at that time was officing in the Drexel Bank building at 40th and Oakwood and Cottage. I then had left him 6 months earlier and opened my office at 55th and State. And when he passed away, many of his clients who knew me and knew that I was associated with him came to me. Many of them who had paid Clayton couldn't pay me, and I took the cases out of deference to him and out of respect for him, and did the best I could with it. Most of the cases we won, and from that point on, I was in the criminal practice. That's how it came about. As a matter of fact, one of his clients, whose case I took, was a man named Waddy. I should never forget it. Waddy lived in 59th and Wentworth. The neighborhood was changing at that time from white to black. And there was a white couple who remained in the community and couldn't move because they couldn't get mortgages because of age. And a black came into the tavern at which the white couple and Waddy were socializing and began to utter racial derogatory statements to them. And Waddy came to the defense and said, don't bother these people, so what have you. And Waddy went home, and when he came back with a weapon. And when he walked into the restaurant, the man began to say words to him again, and Waddy shot him and killed him. Clayton was in the middle of representing him when he died. And his wife came to me to represent him. And I took the case and tried the case with a jury. And when the wife took the witness stand of the couple that was being demeaned and denigrated and began to testify, and she broke down and cried. And it was not rehearsed. I didn't know she was going to do it. It's just pure emotion. And she ran down off the witness stand with tears in her eyes in front of the jury and grabbed Waddy and said, you wouldn't be here but for you protecting me. And of course the jury went out, deliberated, and acquitted Waddy. It was a very high profile case. Many of the assistants have said to me that they thought I rehearsed, but truthfully I didn't. I didn't know I was going to do that. Had I known she was going to do it, I told her not to, but I'm glad she did it. But those are the kind of experiences you have in the trial of a case that get you the reputation. And out of that case, I acquired some degree of reputation as being a tremendous trial lawyer. Wasn't a skill on my part in trying the case. I just felt that if a jury heard what happened, that they would be lenient, be sympathetic, and indeed they were. And of course, when the lady, as I said, ran out off the witness stand and grabbed Ward and hugged him and crying and screaming, "You wouldn't be here but for me. You were protecting my honor. You were protecting my honor." And the jury acquitted. Well, that was my beginning of my career as a criminal trial defense lawyer.
Well, apropos of what Gene has just stated about Joe Clayton and his reputation and his, Gene didn't tell you also that he did allude to the fact that Clayton suffered from asthma so badly that he turned that, he couldn't sleep, but he turned that negative into a positive, and he was also so busy that he couldn't have regular business hours, and so therefore he'd sit up in his office and rest and try to sleep, and he would begin his office hours at about midnight.
Oh my goodness.
And when he began his office hours, Gene didn't tell you this, his office would be full of people. And sometimes it would be 4 or 5 o'clock in the morning before he completed going through the people who wanted to see him and talk to him about particular cases. That was the kind of a reputation that he had, that people would come to his office and sit there from 12 to 4 o'clock in the morning just to be able to talk with him about representing them or some person of interest to them in a criminal case. And the highlight of my 4 years as a prosecutor was the one case that I tried to a jury in which the opposing counsel was Joe Clayton. It was an armed robbery. His client was alleged to have robbed a policy wheel collection point, and I was a prosecutor, and that was the only time in my life, and the only case that I ever tried against Joe Clayton, that I beat him in, and that was the high point of my career. I don't know whether you remember that case, G. The armed robbery of the policy joint.
Clayton was a man who finished Northwestern University Law School, I believe, in 1936. Law school. He was married to Edith Sampson, who was the first black alternate delegate to the United Nations, appointed by Harry Truman.
She became a judge also.
She became a judge, yes she did.
Here in Cook County.
In Cook County. Clayton took the position, I was taught this, that when a client comes in, the defense lawyer's obligation to him is to advocate his case and see to it that the rules are complied with, that his side of the controversy is revealed and told. And if the rules are complied with, you're a strong advocate for him, and if the jury says he's guilty, he ought to then be in the penitentiary. Period. It's just that simple, nothing complicated about it. That he's not going to hire you to effectuate or obtain for him an acquittal. The acquittal may be a result of your labor, but that's not where he's hiring you to represent his case and to advocate his case. If as a result of that he's acquitted, fine. So Clayton was a man who believed that and who advocated that and who never turned down a case because the client couldn't pay a fee. And I've been in this profession since June 18th, 1951. And I've never turned down a case. I've never refused to represent a client because he couldn't pay a fee. And I have all my appeals bound in Naugahyde at my home, and I guess it comes to something like 250 of them. And of those appeals, I got paid in perhaps 10 of them. But he was a kind of a lawyer, and we need this in our profession.
I'd like to hear both of you talk a bit about your experiences with the death penalty in your practice.
As a prosecutor, I didn't have any capital cases. I didn't participate in any case in which the death penalty was sought.
By choice, or it just happened that way?
It just happened that way. So I really wasn't faced with that dilemma until after I got into the private practice of law.
Well, the first case that I worked on when I came into the Joe Clayton's office was a capital case, Eugene Philip Childress, and I would invite your viewing audience to look it up. I did have capital cases as a trial lawyer, but I never had cases in which the state's attorney was seriously about trying to obtain the death penalty as a trial lawyer in my practice.
Is that because they thought you were such a formidable adversary that they couldn't get it?
I would want to be egotistical enough to say that that probably was the case. And indeed it probably was. As a judge, and I never had a case in which the jury imposed the death penalty in my entire practice. I had cases in which they kind of meekly asked for it, but they weren't serious about it, and I knew they weren't serious. But so in answer to your question, as a trial lawyer, I didn't have the turmoil and the furor of defending a capital case. On the bench, as a trial judge, I sat at 26 in California from 1976, December of 1976, until July of 1984. And there was no debate in my courtroom that I would not sentence a defendant to death. I would tell the state's attorney that up front. I let him know that at the beginning, and if you're serious about asking for it, I'll send the case out. But I will not, under any circumstances, sentence a man to die. I'm not going to do it.
Now, when you say you would tell the state's attorney that, would you tell the state's attorney that confidentially in chambers?
No, in open court.
In open court?
In open court, yes.
As the case started. And what would the state's attorney do?
Invariably, they would say, okay, we'll leave the case here. I never had them to ask me to send the case out. And in my tenure on the bench, the 8 years I was there, no jury ever imposed the death penalty. And in fact, I don't recall them even asking the jury to impose the death penalty in the case in which I presided over, because they knew up front I was not going to do it.
Were there other judges at that time who took that stand?
There was some. But I was adamantly opposed to it. I let it be known up front that I was opposed to it, philosophically and religiously, and I made no bones about it. And I would say to the prosecutors, if you feel that it's a case in which death is warranted punishment, tell me and I will transfer the case out so that you get a fair shot at it. But they never did that, and I never had so I didn't have a problem.
Well, I had the same philosophical and moral opposition to the one human being imposing the death penalty on another for those reasons, because I didn't feel that as a human being that I should have the power to say that one person dies and another person lives. But I balanced that moral and philosophical opposition when I sat on the bench, and I sat for 28 years, 24 of them over at 26 in California, with the fact that the law called for the imposition of the death penalty, that I, as a judge, when I took my oath, swore to follow the law, and therefore in those cases that death was asked for, and if the jury found for death, then I would impose that penalty because I was obligated to follow the law. But and I presently have 6 people on death row or before the moratorium. But I can say that of those 6, I have no reservations whatsoever about the imposition of death in their cases because those 6 committed crimes that I have no compunction in saying that I had no feeling that in any way, shape, or form that was not the proper punishment for them. But I sentenced them because the law said it was proper, but also on the basis of the old biblical principle of an eye for an eye and a tooth for a tooth. And that's the way I moralized it and got over my moral dilemma.
Sense I got was that members of the bar out there were colleagues. There was a collegial atmosphere. And I wondered if both of you could comment on what the genesis of that culture was and whether it's the same today.
Well, the genesis of it was, I believe, the respect that each party in the courtroom setting had in those days, for the most part, for the rule of law. The respect that everybody had for how the process was a process that sought truth. The belief that each party had that the rule of law was sacrosanct, and the rule of law was that determined what went on in the courtroom setting.
Judge Pincham, could I ask you to comment on that same question?
We were taught, and we believed, I still believe it, that in this profession we are a family. We were taught this. We were indoctrinated with this. We were culturalized into the concept that the legal profession is a family. And it's a family composed of different members. The prosecutor is a member of the family. The defense lawyer is a member of the family. The police officer is a member of the family. The judge is a member of the family. The court attaches. And that when we walk into the courtroom, the family is engaged in dispensing justice by the rules. And then when you walk out of the courtroom, we're still in the family.
Now, has that changed?
Oh my gosh, yes.
Justice Strayhorn, Judge Strayhorn, what do you think?
Lord, yes.
Well, there isn't that degree of collegiality now that existed back when Gene and I first became friends back in the late 40s and from there on.
Why do you think that's true?
I would venture to say that I find it hard to explain. I really can't give an explanation that makes sense.
I think it's because of the expansion of the profession, the accelerated expansion of the profession without the indoctrination attendant with it. I think we arrived at a point where producing lawyers without giving them the basic principles upon which they operate as a moral institution. I think also that the competitive enterprise in these prosecutors' offices, the cliques that go on in the office, this attitude, win at all cost, motivating prosecutors to do things that otherwise they would not do, motivating defense attorneys to do things that they otherwise would not do, motivating judges to do things that they otherwise would not do, has brought about this undesired change.
Do you think that race has anything to do with it?
Oh, absolutely, it has something to do with it. There's no question about it.
What?
Race as well as sexism has something to do with it. Years ago, for example, I recall a judge, John P. Barnes, United States District Court chief judge, I tried a case before him, sale of narcotics. state, the government rested, defense rested. Barnes stood up and walked back and forth behind the bar for at least 10 minutes. And finally looked at the defendant and said, "You did it. I know you did it. There's no question in my mind you did it. But that's not what I'm here to decide, what I believe or what I think. The question is, has it been proven beyond a reasonable doubt? And if it took me 20 minutes to walk back and forth to make that decision, I find it has not been proven and I quit you." And he did acquit it. That attitude no longer prevails in our system.
But what's the relationship of that to race?
You cannot eliminate race out of a courtroom as much as we'd like to. We live it every day. We live in black communities, white communities. We work in white areas, black areas. And to suggest that racism is not present in the courtroom is being unrealistic. It's just simply being unrealistic. For example, today in the State's Attorney's Office of Cook County, you have 1,000 assistant state's attorneys, as compared to what, about maybe 50, 60 when we started practicing law. And of the 1,000 assistants in the courtroom today at Cook County, there's not one single black assigned to a courtroom as a felony trial assistant state's attorney.
Why is that, do you think?
Racism, pure unadulterated racism.
I mean, you think the State's Attorney's Office is turning down qualified black applicants?
Not only turning them down, but refusing to allow them to advance to the point of being first chair assistants in a courtroom. Of course it's racism. When you have, for example, the penal system in America is now housing over 1.5 million inmates. And of the 1.5 million inmates that are being housed there, 2/3 of them are black throughout America. Of course there's racism in the system. And in fact, and when the persons who are sending them to jail are predominantly white judges, white prosecutors, white policemen, white deputy sheriffs, white jailers, but black defendants.
What was the composite? Do you remember back when you started practicing what the proportion of black to white defendants might have been?
It was not what it is today. It was disproportionate, of course, but it was not as disproportionate then as it is now.
Judge Strayhorn, did you have a comment on that?
In terms of the proportionality of the races in the criminal on the criminal side, I would say that when I first started in the office, which was around in 1948, it wasn't 50-50. And now I don't know what the proportion is, but I'm certain it's a greatly more than 50% black.
I wanted to ask you both what you think the genesis of the Greylord scandal was. What in history produced that? Because there were 20 judges who were eventually convicted and sentenced. And whether that problem, whatever it was, has been solved. Could you give your, Judge Strayhorn, could I start with you, and could you give us your comments?
Well, the genesis was the fact that always, even back in the days when I first began to practice, there was an undercurrent of a culture of undue influence existing in our court system. Except in those days, the people that were involved in it, the judges that were involved in it, those lawyers who were involved in it were a minute few in it, and it wasn't as widespread as it became through the Greylord scandal. So that kind of a current culture has always been present in the system, insofar as my understanding and my experience in the system in Cook County has been. It just wasn't as widespread, and it wasn't as outwardly practiced as it became in the Greylord matter.
What do you think caused it to become more of a problem than going into the late 60s, 70s?
Arrogance, a belief that I'm not gonna get caught, or what I'm doing is no worse than what some other politician is doing or what some other judge is doing, and a disregard and a feeling of really disrespect for oneself, because there's got to be a feeling in an individual that I take money under the table in order to render a ruling that I don't really feel is justified under the law and the evidence in the case. And I have sworn to follow the rule of law when I took the oath of office. Hey, that kind of a imbalance in an individual has got to affect them. And it becomes easy, it became easy, they thought, to do these things and get away with them.
Second, what about political influence, not just money under the table, but political influence upon judges, especially given the fact that judges are elected and dependent on the political process to be elected?
Political influence was never a factor on me when I was a judge. So I think that just based upon my own experience as a judge, that the manifestation of political influence on judicial decisions is overrated.
Mr. Pincham, could we ask you about what you believe to be the genesis of the Greylord scandal? And
I don't understand it. I am not going to sit here and try to make you think that I do, because I don't. I just don't understand the genesis of it. I can say this. One, by far, most of the judges were honest, law-abiding, God-fearing, righteous individuals. There were a few who corrupted the system. How it came about, or why they did it, I cannot answer that. I just don't know. It's just difficult for me to fathom a person being of a moral fiber, that greed of money, they would render decisions based upon somebody giving them some money. And yet we know it happened. We know that it happened. Why it happened, or how it happened, how these persons were able to get into these positions of power and trust with that kind of moral fiber, I can't answer that. I don't know. We know it happened. It's tragic that it happened. And I detected, perhaps from the question that you put, that it was by election of judges. I am adamantly opposed to the appointment of the judiciary. I adamantly support the election of judges by the people. I think that the people should have their final say in the election of judges, and I think that from the street on which I live on a street when I came along, when I was admitted to the bar, there was one black judge in the state of Illinois. And we struggled throughout the 50-something years I've been in this profession to get more blacks and more women on the bench. And I would be the first to stand up and tell you I'm adamantly opposed to taking away from the people their power to elect their judges. And if they elect corrupt judges, they can defeat corrupt judges.
Tell us about the process of your own coming to be nominated and run for election, both starting with you, Judge Pincham, and then going to you, Judge
It might sound
Strayhorn.
somewhat pompous or arrogant to you, but I was asked to run for judge in 1970, in 1972, in 1974. I declined. In 1975, when the slating was about to take place, I got a call from the mayor's office asking me to run, and I again declined. I had no ambition or desire to be a judge. I loved the practice, I was enjoying it, I was having a good time, and I was serving, I was helping. The call came about 2 o'clock in the morning, confidential. We want you on the ticket because there's a scandal going on, and we want somebody with some integrity on the bench to minimize the scandal and so forth, so I declined. When I hung up the phone, my wife said to me, let's talk. She said to me, you have always advocated that to us in our family, that if everybody's going east and you're the only person going west, don't you stop and go east because everybody else is going west. But at least you stop going east and ask everybody, why are you going west and not going east? And then make a decision as to whether you want to continue to go east or you want to turn around and go west, or whether you want to stop, period. And she said, I heard the conversation. And she said, why is everybody else going west and you're the only one going east? I said, what do you mean by that? She said, there are 40,000 people in Chicago right now who'd love to get the call you just got. 40,000 lawyers would love to be heard saying, we want you to run as a judge. Why they want it and you don't? It's a different personality. She said, well, give it some thought. Because you're the only one going east, everybody else going west. When I got to court that morning, the presiding judge was Fitzgerald, Richard, chief judge. When I opened the door of the courtroom, Gene, come here. I went back to him and says, you turned down the mayor when he asked you to run for judge last night. I said, I thought the call was supposed to be confidential. He said, well, think about it. He said, you just can't continue to do that. He said, we need you. We need people with your skills, your talent, what have you. I said, well, I think about it. Fine. I shall never forget this. I left there and I went to the 7th floor, room 704. To this day, I cannot remember who the judge was. But when I opened the door, if you're familiar with 26 in California, courtrooms are long. When I opened the door, the judge was sitting on the bench. Gene, come up here. Took me to the chambers. He said, I heard you turned down running for judge last night. I said, I thought it was again confidential. He said, nothing confidential in a democracy. And I remember that. He said, there are no secrets in a democracy. He said, give it a try, think about it, and run. And if you don't like it, you can leave. I went home and told my wife, and she, the wisest decision my wife ever made for me, bless her sweet soul. She said, you're running for judge. So I called and said, yes, I'll run, and I did run, and I became a judge, was elected. I'm glad I did. I enjoyed the experience. I enjoyed the being in a position to help somebody. I enjoyed trying to serve in a capacity to set an example. I left the circuit court in 1984 and went to the appellate court. I sat there until 1990. I enjoyed that experience. I must confess to you that after being on the trial level for 3 or 4 years, I became bored. In the appellate court, after I was there for 2 or 3 years, I became bored. I left the bench in 1990, resigned to run for Democratic Party nominee for President of Cook County Board when the party refused to slate John Stroger because he's black. And it was an insult to our community, and I took it to be an insult because the president has always come from the chairman of the Finance Committee. Stroger was the chairman of the Finance Committee, and they refused to slate him. And I gave it some thought. My conscience wouldn't allow me to take it, and I resigned and ran for president of the county board. Didn't win, but 4 years later, Stroger did receive the nomination, and as you know, he's the president of Cook County Board to this day, as we sit here talking now. I ran for mayor in the general election of 1991, I believe it was. Enjoyed doing that. Again, because we were the most disciplined, the most loyal, the most dedicated voter in the Democratic Party, black Chicagoans, and we were not getting our fair share of the benefits of our votes. And I felt that somebody should stand up and speak up against it, and I ran to protest the discrimination that was being inflicted upon black people by the Democratic Party in Cook County, and I would hope to believe that some of the benefits are now being derived from it. For example, now we have black Secretary of State, Jesse White. We have Obama running now for senator of the state. It's quite common. Black folks have been voting for white folks ever since black folks have been voting. And we just felt it's time white folks vote for black folks too. that race should not be a factor in an election, but it has been, and if we ignore it and allow it to go without unchallenged, it will continue to exist. But now we're beginning to face it and confront it, and now we're beginning to persuade people to vote for the candidate, regardless of color, based upon qualifications. And I'd like to think that I contributed something to that.
Judge Strayhorn, what about you? How did you get to be a judge, and what was your experience with the electoral process of judges?
I was his first campaign manager. He lost the first time around.
I ran, well, first, I think that my experience of getting on the bench was sort of pre-planned, because I started out in my law career with a secret desire. I didn't much express it, but a secret desire to at some point be a judge. And everything I did in the law and in my practice was directed toward that aim. And I became involved in politics through the Second Ward organization of William Dawson, who was a Democratic power, and I was his legal counsel for his ward organization. And it was Congressman Dawson that pushed my candidacy to go on the bench at a period of time when there were few blacks on the bench. And in 1970, he pushed me for one of the Democratic slots, and I ran on the Democratic ticket. And for the first time in 100 years, not really 100 years, but for the first time in a long, long time, that was a year that there was a Republican landslide. And all the Republican candidates, with the exception of one Democrat who actually was a Republican, and that was Reverend Archibald Carey, who ran as a Democratic candidate, but he was actually a Republican.
So was he your opposition?
And no, he wasn't. My opposition was Reggie Holzer,
That's right.
who was one of the Greylord people.
Really?
Yes, ma'am.
And when I ended up finally getting elected in 1974, I took the courtroom that Judge Holzer had served in room 706, and he left a few things in the chambers which I refused to even touch with my fingers because of the reputation that he had
What kinds of things did he leave?
Newsreel, enclosed in a newsreel case, and some other materials that he had back there in the chambers that I wouldn't even touch. I called down to the chief judge and asked him to have those things removed from my chambers.
Why did you do that?
Because of my disregard for Judge Holzer and the things that he had done to bring a disrepute to himself and to the bench.
Was that having anything to do with the Bienen case?
That was a part of it.
Could you tell us just a little bit about the Bienen case?
Bienen case, Dr. Bienen, who was the son, incidentally, of a very, very highly regarded lawyer, who was a public defender.
He was the first public defender, I believe.
First black.
First black
public defender, yeah.
of Cook County. And his son was charged with the murder of his wife. And there was some shenanigans that went on in that case. And rumors went out about those shenanigans. But he eventually ended up, he was convicted, but that was the genesis of the beginning of the Greylord scandal. Things that went on in that Bienen case, I believe.
Could you both talk about the dilemma of, and I was myself faced with this, over the years, but faced with the dilemma of having some knowledge that there was a problem in the judicial system and among lawyers, misconduct. And the notion that within our profession we have a duty to report misconduct. Why do you think it was that it took a federal investigation to bring the misconduct to light instead of people actually reporting what they knew or what they assumed was happening?
Human conduct of not wanting to point the finger at someone else, primarily. Secondly, aside from the fact that this is rumor, I never saw any actual misconduct take place in my presence that I could have reported. So rather than be involved in reporting innuendo, then on my part, you draw back.
Justice Pincham?
But at the same time, you would put the little tidbit that you had available to you in the back of your mind, and I would always be leery of any dealings professionally or personally with any of those individuals after that.
Justice Pincham, could you comment?
We knew, and I'll be candid to tell you, we knew who the few corrupt judges were. I was indoctrinated in law school as well as by Joe Clayton, as well as by my mother down in the foothills of Limestone County, Alabama, to do right, to do that which you know is right. And I can sit here and tell you that when I was in law school, they didn't even teach ethics when I was in law school. I never had a course in ethics in law school. But you know what's right and what's wrong. And Clayton used to always say to me, you practice law and you live the life as though J. Edgar Hoover, who at that time was head of the FBI, is on your right shoulder and Jesus Christ is on your left shoulder at all times. And that's the principle I follow. We followed it. When you ask me why didn't you expose those who did it, because you, as Earl has stated, you didn't actually see it, but you knew what was going on. But more importantly, there was a bond, and that bond was we are family. That bond was we love one another. That bond was we support one another. That bond was it's the judicial, it's the legal profession. And when the Supreme Court came down with the Himmel decision, holding that you are violating the canon of ethics when you know of a violation, don't report it, I was incensed. I was just incensed. You're compelling us to become stool pigeons. You're compelling us to snitch on one another. And it only demonstrated how brilliant the Supreme Court justices were and how stupid I was. It was one of the wisest decisions the court has ever made. And that decision requires us now to police our own profession. It requires us, and I think they're right, after reflecting on it and thinking about it and analyzing it, the court was right. I was wrong in my attitude. We should police our own. I don't want to be in a profession of lawyers when I know they're doing wrong and violating the oath and abusing people and selling justice. I don't want to be in a profession where lawyers are not doing right and betraying their clients. I want to be in a profession where I can look at a lawyer and say, I know, brother, you're all right. I know you're doing the right thing. And I think this policing of each other in the profession ought to extend to the medical profession. It ought to extend to the clergy. It ought to extend to the police department and law enforcement. One of the problems in law enforcement today is this code of silence, the failure and the refusal to police their own.
I want to ask you a question just to follow up on the discussion of Greylord, whether that was obviously a very tragic time for the court system. Is there any similar phenomenon or culture that is in existence now that we need to worry about in the same way that we were worried about judicial corruption back in the 70s?
Absolutely. And that is the few police officers, the few prosecuting attorneys who are deliberately engaged in purposely framing defendants and convicting them of crimes that they did not commit or perjured and concocted and fabricated evidence. That is present in the system today in Cook County, Illinois. And when Governor Ryan pardoned those individuals that he did as he was leaving office, he was absolutely correct and right. And as recently as day before yesterday, we were reading of a case where the two young men who were convicted 27 years ago of a murder and a rape on concocted, fabricated, suborned, perjured testimony by the prosecutors and by police officers.
What about the issue of police coercion, torture, and that kind of thing?
The problem is, one, that it exists. But more serious than that is the fact that when it is disclosed and revealed, no action is taken against the policeman or against the prosecuting attorney. That's your problem. When a lawyer is caught doing something wrong, he's taken before the ARDC and he's disbarred. A judge is caught doing wrong, he's taken before the Illinois Judicial Commission and he's suspended or he's removed from the bench. A cop gets caught doing something wrong, or a prosecutor gets caught doing something wrong, subverting perjury, no action is taken. You got policemen now, in the Ford Heights 4, for example, in the Rossetti 4, for example, Anthony Porter's case, for example, the Lisa Kabasi case, for example, where it's been disclosed beyond a shadow of a doubt through DNA evidence, in the Ford Heights 4, the two persons who actually committed the crime came forward and admitted the crime, confessed to the crime, causing the four defendants, black defendants who have been convicted, to be released. And the two people who admitted the crime who are now serving sentence for having done so. But the policemen who framed them, nothing has happened to them. I've got to tell you this. When I was sworn in, my mother came to Springfield, Illinois, from Limestone County, Alabama, on a Greyhound bus. This was BCR, before the Civil Rights, and she had used, they didn't have latrines on the bus. The bus stopped. They had to go to the segregated washroom. But anyway, she came to Springfield, so I was sworn in. And after I was sworn in, taking her back to the bus station, she said something to me that was very, very, very impressionable. And it's been with me all these years. They didn't teach me this in law school. What she said to me was, you are in a very, very unique profession. It's different from any other profession, any other business, any other vocation that there is. She said, people will come into your office and sit down, never saw you before in life, know nothing about you except your reputation, and will then tell you their innermost secrets. Their innermost secrets. They will tell you, yes, I was disloyal to my wife, I've been guilty of fidelity, I want you to represent me in a divorce case. Yes, Mr. Pincham, I did shoot him, and he did so-and-so. I want you to represent me in a murder case. And she said, not only will they tell you their innermost secrets, son, they will then pay you in advance. And so no place else in America do they do that. So you don't go into a store and take a suit out and then pay the man next week. He says you can pay it on time, but in the legal profession, people pay you up front to represent them. And she said to me, you are in a position to betray a trust. But she looked in my eyes and said, but I know you won't because I raised you. You'll never take advantage of anybody. And I can sit here and tell you that in all my practice at the bar, I had one complaint with the ARDC, the Bar Association. And that one was frivolous. That, and I'm not trying to pin rules on me. God has been good to me. He brought me out of the mire of poverty in Limestone County, ignorance, superstition, into a level of sitting here talking to you. I'm blessed.
But Gene, I think you ought to tell the real reason that you and I were not involved in that mire that was Greylord came from within our own stomach, and our determination not to be a bought person, not to have a ring in our nose by someone who came in and gave me $1 to do something that was improper. And after that fact would be able to get me to do something that was improper for nothing. A feeling that I wasn't going to be a bought person, a feeling that I had respect not only for the position that I held, but I had a respect for myself, that I'm going to do the best I can to follow the law as I understand the law to be. And there's not enough money in the world that anybody can give me to make me straight from that view. And I'll close and then I'm through. The proudest moment in my career was to hear revealed to me the testimony of one of the undercover agents in the Greylord case, who was asked in open court in talking about the judge that was on trial, did you approach Strayhorn and did you approach Pincham? And it was reported to me that his response was in open court on the record,
Under oath.
under oath, was, no, I didn't approach a Strayhorn or Pincham, because everyone knew that they weren't approachable. And that was that's what I like to have on my gravestone.
Or you've had cases where the client would walk up to you after you're in the case. Do you know the judge? Of course I know the judge. I know what they're getting at when they started. But can you talk to the judge? Of course I talk to him when I see him in the courtroom. I say good morning to him, he say good morning to me. No, I mean, but can you go back in the back and talk to him? Say, what do you mean go back in the back? Well, you know, so-and-so and so, no, we don't do that. I've had clients to tell me, well, you keep the money I paid you, would you object if I go get another lawyer? Because he tells me he can do so-and-so and so-and-so. Fine. I had clients come to me, do you know the policeman? He's going to say he saw me dropped it unless you go talk to him. Well, if he's waiting for me to talk to him, he's going to say he saw you dropped it, because I'm not going to talk to him.
You talked about the difference in judges and difference that you observed with respect to prosecutors, the legal culture as a whole, but what about the quality of defense counsel over the years?
The quality of defense lawyering generally has gone down in Cook County. And that has been primarily because it's very difficult for a lawyer to specialize in criminal law, because he's not going to be paid. And lawyers, after all, have families and other obligations, and there should be some reward coming to them from their practice of the skill of law. And so now we're not getting the kinds of lawyers like Eugene Pincham that are going over into the criminal courts. Of
What has caused that change? I mean, what accounts for the
economics?
So
The rise in the number of blacks in the system, the fact that most of the blacks in the system are poor and impoverished and unable to afford the kind of representation that a good lawyer would bring them.
But was it different when you started practicing? I mean, were there more? Did defendants have more resources to pay?
They had more resources.
There was no public defender.
Well,
Yes,
there
sir.
was the beginning of the public defender
Not safe.
system. Yes. That was right at the beginning of the public defender system when we were coming in. The public defender had probably been in existence then for maybe 10 or 15 years when we started. But the system wasn't overburdened as it is now. We could close, and they did. They closed the criminal court down 2 months every year. Now, if you close a criminal court down 2 months, it's never going to catch up.
I think that the caliber, the quality of the defense bar has depreciated over the years. And I don't want to offend anybody when I say this, but I just don't know how to be courteous except to speak the truth. I think that the quality and the caliber of the judiciary is not what it used to be. I think that the focus in the profession has been changed. I think that the hue and cry some years ago about law and order has distorted the courtroom. I think that what makes our system work is the respect that the people have for it. Defendants who commit or who are accused of committing crimes are willing to become involved in the system's process of determining whether or not they committed the crime, and are willing to accept the results of that determination because they have respect for the system, not because of force. Man gets out on bond tomorrow and goes to court for the next 2 or 3 years. He's not going to court because he's afraid. He's going because he's been culturized into believing I'm going to get a fair shake, that the rules are going to be followed. If the rules are followed, I may be acquitted. If the rules are followed, I may be convicted. But it now is at the point where that respect is being depreciated, is being declined, it's on the decline because of what people see in the system. And I think it's going to ultimately inure to our detriment. And I think that there's going to have to be a concerted effort on the part of the power structure to reconfirm to the public the integrity of the system, the honesty of the system. It's not only in the criminal field, it's not only among blacks. Just read the other day where the Enron officials were laughing about what they had accomplished. You got high executives making millions of dollars a year, engaged in conspiracies to fix prices and this kind of thing. It's greed. It's greed, and it comes from the top all the way down to the bottom. You had a man who was president of the United States at one time, engaged in the petty offense of burglarizing a political office. And although he was lost the office, but that kind of mentality has got to be addressed at some point, and this must be addressed, I'm suggesting to you, in the very near future. Because if the people who are being subjected to the system, the people who are being accused, many of them rightly so, many of them wrongly so, if they ever arrive at the point where they disrespect the system, we're going to have chaos. You can't have a policeman standing on every corner in America and have a democracy. You can have a soldier standing on every street, riding every bus. It's the respect that people have for the system, and that respect is on the decline because the moral fiber of the system is not what it once was. And I suggest to you that the solution is going to have to be, we must begin to insist that each ingredient of our culture police its own. Journalists must police journalists. Media people must police media people. Judges must police judges. Police must police themselves. Medical profession, medical malpractice. There was a time back 25 years ago, you couldn't get a medical malpractice doctor to come in to say that this doctor committed malpractice. That's not no longer true. But I think that's the solution.
Would either of you like to comment on capital punishment and its role in the political process, particularly since as part of this project, we have some research which has shown that in times when judges are being elected, juries are more likely to impose the death sentence.
I'm opposed to the death sentence as a punishment in our system. The reason being that I feel that the public has been given the wrong reasons for the use of the death sentence as a punishment. If the death sentence is imposed on an individual as punishment, then I'm much more comfortable than the reason that is given presently for the imposition of the death penalty in our criminal justice system, being as a deterrence to others committing the same kind of a crime. But if the public says that we're going to kill you because you killed another human being, then I can live with that better than I live with I'm going to kill you to deter Tom from committing the same kind of act, because it's not true, and it's inhuman.
I'm not going to change anybody's mind about it, and I'm not going to try to change anybody's mind about it, and certainly nobody's going to change my mind about it. By and large, if I'm wrong, when I get to the gate, I won't have to answer for it. If I'm right, I won't have to answer for it. But the concept during election years, law and order, crime in the streets, in my judgment, inappropriately motivates and induces the culture to be more harsh in dealing with the convicted offender, including imposing the death penalty. Nobody can make a convincing argument that it is a deterrent to commission a crime. It isn't. If it was a deterrent, it wouldn't have been about on death row, period. But I just happen to believe that the root cause of crime is not being dealt with when we divert it to law and order, crime in the streets, make our streets safe, what have you. Root cause of crime, ignorance, cultural degradation, emotion, poverty. And yet, I mentioned a moment ago, we have multimillionaires deliberately engaging in criminal conduct. And I have never understood why it is a man with $10 million will see a need to steal.
The practice of law is an honorable profession. It's an important profession, and it does good when it is practiced properly.
That's right. There's nothing more rewarding than to come out of a courtroom with a not guilty verdict, where the rules have demanded it, to give the person who's been charged and acquitted a second chance to end up doing what's right. It's a rewarding feeling. And I've had it many a time, many a time.